ඇහෙන්නේ හැලු මේගොල්ලන්ට. මගේ මයික් එක ඕන් කරන්න. Hello.
Yes, sir.
Hello.
You can hear me, no?
Yes, sir. Now
One moment. The host will address you. One moment.
Right. Can you hear me and can you see me?
Yes, proceed. Yeah.
Right. Okay. Sorry for the interruption because of a technical issue, actually. Thank you very much. And good evening and welcome all of you for the workshop on new updates of Labour Law 2023. We, National Institute of Labour Studies of Sri Lanka, NILS, we are going to conduct this program free of charge for a large amount of audience. Actually, I think we have about 56 people already joined with this program. And let me take 1 minute to tell about the National Institute of Labour Studies of Sri Lanka. Actually, we are the foremost pioneers in labour law and labour relations of Sri Lanka, established about 12 years back. It's a government organization, NILS, National Institute of Labour Studies of Sri Lanka. As a government institute, we are under the Department of Labour and Ministry of Labour. So our headquarters is located at 3rd floor in Labour Department, Narayanpeta. As NILS, we conduct this kind of programs like one-day programs and short courses, diploma programs on labor relations and industrial law, human resource management programs. So this is one of the emerging things that we have decided, because there are a lot of compliance obligation changes recent. So we are going to take one of the expert person to conduct this lecture on behalf of all of you. So let me introduce the resource person today. He's Mr. Ranaweera. Most of you might have heard about him. Actually, he's a former commissioner of labor, and he has almost 38 years experience in Department of Labor Sri Lanka. So he has worked for Labor Department for 38 years. And before he became a commissioner, he held a deputy commissioner role in enforcement of law, and he was working as in charge of labor standards before he became a commissioner. So as a deputy commissioner, during that time he has conducted a lot of ILO assignments. Like he represented Sri Lanka as the Sri Lankan government delegates for more than 20-25 ILO conferences and international conferences, and then he held like representative Sri Lanka for more than 40 countries. And a part of that, actually, he was with us. He has been with us for more than 10 years. So as a visiting lecturer for NILS, he joined with us in 2010. So almost 12 years he was working with us. So let me invite Mr. Ranaweera to conduct this program from now onwards. Welcome you, sir.
Good evening, participants. I'm thankful to Lakshita for introducing me to you all this evening. My main topic today will be Labor Law Update 2023, New Compliance Obligations. In short, what is expected out of this presentation would be to enlighten you on the update of the labor laws and the published in that. Yeah. Okay, you all can hear me now? Can you all hear me? Hello?
yes,
Yes,
sir.
sir.
Yes, sir. Yes, sir.
Yeah, I can hear.
Yes, yes, sir. Then in that book, we had 23 labor enactments published there. That was in 2010. But for your information, I should tell you all that there are actually about 42 labor enactments, Sri Lanka, 42 labor enactments. Some are outdated, some are now obsolete, not wanted. But the 23 which was there in the labor code of Sri Lanka in 2010, of course, will be valuable in some way or other, because those 23 enactments are sort of should be useful. Anyway, after 2010, there are about 18 new amendments and new labor laws. So I'm now trying to touch upon those labor enactments which have come after 2010 up to 2023, which are very important and amended and new laws. So for that purpose, I have selected those 18. I'll try my level best to go through the 18, but with the time constraint, we'll see how we can go forward and tell you all. I don't want to waste your time. I'm waiting for the next one. That is context. Since 1865, over 50 labor legislations have been promulgated to protect labor and regulate industrial relations. Now, when you talk of labor law, you must always remember the word going along with that word is industrial relations. The entire purpose of the labor laws are to see that there is peace in industrial workplaces and industrial relations, employer, employee, and the state. So there are the three sectors must go together, and there should be very peaceful understanding among these people. That is why this word industrial relations go in that. Anyway, 1865 means this Indian labor, which was brought from Talemana, that was from South India. They were brought because of the plantations, mainly tea, rubber, and cocoa. So for that purpose, our labor enactments goes back to the history of 1865. That is why 1865, from that time, the labor laws were introduced and promulgated from that time. Because of the Indian labor only, our labor laws got rich and richer, because the Indian labor, we had to protect them. The government of Sri Lanka at that time had to look after them, protect them, and see that their well-being. That's it. So, however, in day-to-day activities, about 15 legislations have been considered important. The successive governments have taken measures to update labor legislation by way of amendments to the existing legislation, amendments to the existing legislation. So existing legislation, we find, as for the time, as the time comes on, with the economic and political arena in the country, these existing legislations will had to be sort of amended to go with the economic situation and the labor force and other concerns affecting this labor and employers. So anyway, then introducing new pieces of legislation depending on the changing socio-economic and political landscape of the country. In 2010, the Ministry of Labor published the Labor Code of Sri Lanka, which was a consolidation of important legislation up to 2010. Then now, one moment. Objective I have, since 2010 to date, number of important labor changes have been made to legislation either by way of amendments or new pieces of legislation. It is important for labor practitioners such as employers, human resource managers, trade union leaders, as well as students to be familiar with new changes. The objective of this webinar is to make labor practitioners, students, and other interested persons update themselves by acquainting themselves with the currently applicable legislation. Then, before I get into the main topic and starting the lecture from that point, I thought to enlighten you all or to keep you informed of some of the most important labor legislations of Sri Lanka, which are now at present, which we are facing and undergoing and being practiced. So, Employees Provident Fund, I don't know deal much on that. I want to just highlight on one or two words. An act to establish a provident fund for the benefit of certain classes. I'm not going to elaborate on that. Certain classes of employees and provide for matters connected there. So the legal draftman has inserted that word. Certain classes means if you go through the Employees Provident Fund Act itself, go through carefully, you will understand what is meant by certain classes of employees because there are certain classes of employees who are not covered under the Provident Fund. Coming on to Maternity Benefits Ordinance, a very old piece of legislation, 1939, number 32. An ordinance to make provision for the payment of maternity benefits to women workers and for other matters incidental to employment of such women. Other matters, remember the word, other matters incidental to employment of such women before and after their confinement. Now, main thing is confinement, delivery of children, delivery of children at the main point. And this refers to the women workers, female workers who are not in the Shop and Office Employees Act. All these women workers working in factories, plantation, industries, services, who are not directly coming under the Shop and Office Employees Act, applicability of this maternity benefits ordinance will be there for them. That's the main idea, you see, of the maternity. Then coming on to Shop and Office Employees Regulation of Remuneration Act, 1954. This is a more sophisticated piece of legislation, whereby when you compare with the other labor laws presently and at that time also, this was a little giving more facilities, and upgraded labor law. So the act provides for the regulation of employment, hours of work. Remember, the hours of work and remuneration of persons in shops and offices for matters connected therewith. In this also, you have, in the shop and office also, you have the maternity benefits under section 18H. But there were a lot of differences with the maternity benefits ordinance on confinement and childbirth, and the Shop and Office Employees Act and the confinement children, there were differences. So, but now, as you go on down in my lecture, most of these differences have been sorted out, and they have been brought into to become entitlements, more or less the same. I will be going through when I get to that point down when I go down. So then wages boards are very old piece of legislation, 41. This is for regulation of wages and other employment of persons employed in trades, because this word trades goes in for 43 labor. We have wages boards on 43 different trades. Karmanta, you call it, the word simple term is karmanta, and it goes as trades. There are 43 wages boards. The mainly thing is to fix the minimum wages, and after that, 2 working hours, then the holidays, annual holidays, public holidays, weekly holidays, public holidays, all that is there. So these are subsidiary. The wages boards wages board decides and publish, and they become laws, that those laws are known as subsidiary legislation. Subsidiary main legislation is 1941 to 27, and those decisions made by the wages boards are known as subsidiary legislation, and in that the main focus is on the minimum wages and the other working conditions. But when you compare with the shop and office, this is more or less lesser privileges and lesser things have been given under this, because this is those days, because actually this was for the manual labor. Now the shop and office was for the white collar jobs, white collar employees. Now this is actually blue collared. They call it blue collared workers, and for the manual workers. But nowadays, of course, we have the journalist trade and all that. So that word is now not applicable as it is. Then coming on to Industrial Disputes Act number 43 of 1950, these are very important piece of legislation, 1950, and because of the rift between the employer and employee, then the labor tribunals, then the industrial court, then the arbitrators, all that is in under this piece of legislation, where any sort of disputes, misunderstandings, or dismissals, or privileges and non-payment of wages, overtime, whatever it is, there will be a dispute, and that is being sorted out under this piece of legislation, and labor tribunals and arbitrators, industrial court, all those things are incorporated in this piece of legislation. Then coming on to factories ordinance, you know, this been this enforced by our engineers in the labor department. We have the mechanical, civil, and electronic, and different types of engineers we have in the department, and their main job is to see the safety and welfare of workers in factories. Now, they have nothing to do with compensation or payment of any money towards injuries or whatever it is. Their duty is to look after the factories and their ventilation, their proper conveniences, and things in the factory, lighting, all those things, and the sound and all that. So coming on to Gratuity Act, today I'm not dealing with that, because there are no amendments to that after 1983. This is, as you know, I'm running through fast, you know, this for the gratuity for the past services. For the past services, if a worker has worked, and apart from the Provident Fund, apart from the Employees Trust Fund, for the past services, he gets this benefit, the gratuity, and there are certain limitations and qualifications that must be sufficed to get this gratuity for them. So there are no amendments after that, few amendments, but I'm not today talking on those. And the coverage for the gratuity and all that, that little extensive, and there's no time to go through that. Then coming on to employment of women, young persons, and children, 56. There are one or two amendments to this. I will deal with that. Mainly the employment of women, female workers, how many hours to work, night work, and then limitations of number of hours in the period of employment. All that is being dealt under the employment of female workers, young persons, who are young persons, 16 and 18, and what are their protections, what are time limits that they could be employed in the night and in the week, how many hours to be employed there, and the overtime rate, all that is being. Then children, who is a child, as you all know, that it's under 16, early at the very stage, at the earlier stage, it was 12 years under is a child, then it became 14 years, then it has now become 16 years under. So under 16, you cannot employ any child in any form of employment, domestic or otherwise. It's criminal offense, punishable with the sentence, imprisonment, and high penalties are there. Therefore, if you keep in mind that under 16, you cannot employ, that's the school-going age. Until 16 years of age, they have to go to school. That's the main idea. So it's okay. Then coming on to the topic. Then termination of employment act, 45 of 1971. There are some amendments. This is they say they, at the very start when in 1971 they said it's a draconian piece of legislation. You can hire people, but you can't fire people. That was the main idea of some of the investors. They said for investors, they said you can hire people, but you can't fire them without the commissioner's permission. So this is regarding the employment, and this is a special unit we have, and the commissioner is empowered under this to pass orders. And in other labor legislation, the commissioner has no power to impose orders or power or give orders. But under this, the authorized officers have the powers of district judge, district court, and taken witnesses under oath, under their swearing, and give evidence and all that high-powered piece of legislation, and the coverage and all that is dealt by, and without the permission of the Commissioner of Labor, you are not entitled to terminate the services under certain conditions only. Workmen's compensation ordinance, remember 1934, nothing to do with the Commission of Labor. The Workmen's Compensation Commissioner is in charge. Workmen's compensation ordinance is in charge of a Workmen's Compensation Commissioner and not the Labor Commissioner. But then as human resource persons or students or practitioners should know that it's for injuries. It's for the injuries at the working time or outside the working. Now they have amended the law that when the people are coming or going back, also now they are covered under this for any injuries and death and partial and total disability, and the rate of compensation, and the death at the time of death, the funeral expenses, and all that is being extensively dealt under this workmen's compensation. There is an amendment to that in the year 2022. Then service contract ordinance 1865, very old, these obsolete, and this is not a practice. But remember, I have introduced this because in this you have the master and servant. They call it the master and servant in 1865. The employer and employee word is not there, and this speaks of the coolies and the kanganis, and that sort of wording is there in that. In this piece of legislation, main thing is monthly based salary has come in with this. You can't pay more you can't extend the period of 1 month and try to pay the workers their earnings. Within 1 month, the consultation, but within 1 month you have got to pay. That rule came in at the very start, introduced by this piece of legislation, and there are how the employee will have to look after their servants, the master will have to look after the servants, all that is their hire and service. Some words there are now not in use now in the present day context. Some are this in 1865, right? Budget relief allowance of workers, 36 for 2005. That was the initial stage that came in. Then budget relief allowance came in the year 2005, then that amended in 2015 and came into finally in 2016. I'll be dealing with that in my presentation. National Minimum Wage of Employees Act number 3 of 2016. There is a national wage now. People who are not governed by wages boards or any other legislation or law, contractual agreements could be there. But anyway, the minimum wage is specified there as the 12,500 is the national minimum wage, which has to be added this budgetary relief allowance of 1,000 rupees in 2005, 1,100 in 2015, and 1,000 rupees in 2016. Altogether 3,500. So that it will be 16,500. But then now if they have joined the workplace after 2005, according to that period only, so that all will not get 3,500, they might get 2,500 or sometimes 1,000. So National Minimum Wage Act number 3 of 2016. Now, coming on to the main topic now, the amendments and the new laws that are coming through, have come through since 2010. Now, Industrial Disputes Amendment Act number 39 of 2011. So remember that if you are taking down notes, please take down the notes so that after 2010, up to 2010, there are about 8 amendments to this Industrial Disputes Act. But after 2010, in the year 2011, there was one known as 39 of 2011. So this one was certified on the 6th of October 2011, and section 43 amended and repealed. Because you have to note down, because if I go to explain what is meant by 43, that will take a long time, because 43 we have so many sections and all that. But just remember that 43 has been amended and repealed of section 1. Any offense committed other than offenses under S.S. section 1 or section 40, magistrate fine not exceeding 5,000 or 12 months imprisonment. Now, what is specifying S.S. is this: under the Industrial Disputes Act, under section 5, under section 32, you find this the labor practices. You see, that was in that incorporated the unfair labor practices. Unfair labor practices came in the year 1999, Act number 56, 1999. This was introduced, and it was unfair labor practices. So in that, you know, these the trade union leaders, there is no word as recognition of trade union, but then trade union were more or less given more power to the office bearers. If they are transferred, if they are they're transferred or dismissed or shifted here and there, and any incentives given by the employers to join, not to join, all that is there in this unfair labor practice. So in that, the fine goes up to 100,000 rupees. For who violates this, the offense goes up. That's what SS means. That refer to that particular section where the fine has been. Pardon? Hello, some disturbance. So this SS section 40 subsection 1, SS means the fine has been increased up to 100,000 rupees for the offences under section 32 as for unfair labor practices. Then magistrate fine, normally for other things, the fine has been increased not to exceeding 500 rupees, the 5,000 rupees. This was about 1,000 rupees. It has been increased to 5,000, and the imprisonment sentence was 6 months. It has been increased to 12 months imprisonment. Can you all hear me, please? Hello. Hello.
Yes,
Yes,
sir.
yes,
Can.
yes, sir. Yeah, hear him, sir. Sir, excuse me.
But I'm thankful to you. You can question me, but then that will, if you question me at this point of time, as the time consent, I might not be able to go forward. Anyway, you can note down and talk to me even later on. So, subsection A.
Excuse me, sir. Excuse me, sir.
Yeah.
Please ask. I think one of the participants, Mr. Rasika Darsani or something. His mic is on. His mic is. Please ask him to off the mic, so otherwise it will be disturbed.
Disturbing. One moment. Who is this person?
Right. Okay. Now he's off
Right.
the mic. Okay.
Thank you. So, not exceeding 1,000 rupees. Remember that in most of the labor issues, the fine doesn't go up to 100,000 rupees, but in certain 2 or 3 enactments, the fine has gone up to 100,000 rupees and 12 months imprisonment of either description. Hard labor, simple labor, whatever it is. In some of the legislation, those have come in. So, and this fine rupee 500 for each day. So after conviction, after finding the employer convicted, found guilty, if there are any delays in the payment and all that, what is imposed on him, for each day, remember, there will be an added amount of fine of 500 rupees. That is what meant by that section. So in the same one, after conviction, if they drag on not abiding by the pronouncement of the judgment, then that will be added fine of 500 rupees for each day. That is what is meant by that. Then coming on to this Act 24 of 22. The other one which has come is 24 of 22, that amendment, section 46. Now here, I want to tell you, section 46, as it was, the representation before the Commission of Labor, no lawyer can come as a lawyer. As attorney at law, they could not present themselves just because attorney at law and present their case before the Commission of Labor. It was not, they are not permissible unless you accompany with the employer and with the proxy and come and appear. So without proxy or employer, power of attorney, the attorney power, the attorneys cannot just by person appear before the Commission of Labor. That was the time. That was in section 46 of the Industrial Disputes Act. Now that has been amended so that the attorneys now can appear, because attorneys were allowed to appear in arbitration cases, in industrial court, and in any other form. They were allowed, but for purpose of a commissioner holding inquiries, personally appearing as attorney was not allowed. But by this amendment, it's allowed now. Now, they say any party to any proceedings under this act taken by or before any authorized officer. Remember the word authorized. The Commissioner of Labor can authorize, maybe a labor officer, he can authorize him for certain special jobs, assignments under the law. Before any, that is the word, remember, not only in this, there are in other enactments also the word authorized officer, especially in writing, the commissioner can authorize that person or persons to carry out the powers, functions and duties. Powers, there are three things: powers, functions and duties of the Commissioner of Labor. Now, arbitrator, now in this, authorized officer, arbitrator, industrial court, or labor tribunal, or commissioner, that's the term there, or commissioner may act through attorney at law or representative of the party. That is, if you keep it in idea, if you mind that section 46 was amended to allow attorneys to appear before the commissioner in person and appearing and for cases. It was not allowed those days prior to this amendment. Then coming on to the other one, for the purpose of this act, a representative of a party shall, where the party is a trade union, you know, trade union under 1935, Trade Union Ordinance number 14 of 1935 has been given powers, a lot of powers for trade union as recognition and appearance and representation, and they can represent workers, so they have additional powers to appear. So where party is a trade union or consist of two or more trade unions. Now, two or more, there is you find the trade unions, two or more trade unions get together, no? So then be a person to represent such union. No, they can now appear as a trade union, where the party consists partly of trade union. The party, they may not be in the full trade union, but then partly consist unions and partly of employees. Remember, workmen who are not members, they are not members of any such union. Be a present be a person to represent such union. In other words, general, remember the word that the representation for the trade unions and for any party, any members who are not fully members of that union also could appear before the Commission of Labor or the other section that I was dealing with to represent matters. Where the party consists of employers or workmen, be prescribed. Remember the word, that's very important. Whenever you come to come through the word prescribe, means prescribed by regulations, prescribed by regulation. So if the regulations have not been prescribed by the minister, there is no meaning in that. Enforcement cannot be done. There are so many drawbacks in some of the legislation where in the year 1978, in some of the sections of the labor law speak of prescription, prescribed, but not prescribed now. Now say in the wages boards ordinance, they say in the salary particulars must be in the prescribed form. But up to now there is no prescribed form. That was 1978, mind you. So any employee, if he just gives a piece of paper saying your salary is 6,000 rupees per month, that's enough. Because it's not prescribed, no. So if it is prescribed, means it should be stating everything what the salary sheet should consist of. So in other words, what is other glaring thing that is coming is under the wages boards ordinance, section 59, they speak of a service certificate as prescribed. So up to now not prescribed. Therefore any employer could just say so and so work with us, and I do not recommend this person to anybody to accept. He's not a suitable worker, because this my experience I have had. I'm just telling you some of the no, very rarely, one or two instances only, some employers have I should not recommend this person to employ in by any other employer, because he's lacking in work and he's not good, because that there is no prescribed form up to now to issue a service certificate. Because the word said prescribed. Up to now, it's not prescribed. I'm just, for your information, maybe as students or practitioners or interested parties, you can go through these particular sections in these enactments and find out where are prescribed, and to go through the regulations to find whether those are prescribed or not. These are going out of the point for you all to enlighten you in some of the drawbacks in these present day labor laws. Then where the parties consist of employers or workmen, be prescribed. Again, the word prescribed. Where the party consists of employers or workmen, be a prescribed number of persons. So the minister will have to regulate and tell these are the numbers. So if the prescription not there and in the regulator doesn't carry this, whole exercise in enforcing this particular section will be void, null and void before the eye of the law, because it's not prescribed. Just remember that word. Wherever you find the word prescribed, that means you have to go through the regulations, find out whether the minister has prescribed or not. Okay. Now going on to the other one. Again, Industrial Disputes Act, Amendment Act number 22 of 22, section 3DD, amended, inserted immediately, subsection, new section, this is a new section. If employer dissatisfied with the High Court, now the Labor Tribunal order, whatever it is, first, when they don't agree, they have to go to the Provincial High Court for a revision. Or for a revision or appeal or whatever it is, they must go to the High Court, Provincial High Court order, which is in favor of workmen. Now, is employer dissatisfied with High Court order which is in favor of workmen, if it is in favor of workmen, on an appeal made by such employer against Labor Tribunal, appeal to the Supreme Court, against such order, he shall furnish to the President of the Labor Tribunal a security in cash where the order which is the subject of such appeal. So in this case, now before they appeal to a higher court, they have to in cash deposit that amount of money with the authority, in this case with the tribunal president. That amount of money in cash will have to be, because without that certificate, that revisionary application or repeal, whatever it is, will not be accepted by the High Court or the Supreme Court unless that carries that certificate issued by the tribunal. Just remember that word. Now, in cash, that is appealing against or revisionary or whatever it is, amendment or quash or whatever it is. Then coming on to only the payment of some of the money to the workman of an equal. If the order is only a salary point, not paid the salary, then that amount must be deposited in cash with the tribunal president. Both the payment of money money and reinstatement. If there's a reinstatement order also, not only the salary point of the reinstatement back to service of such worker of an amount equal to such sum and 12 months monthly salary or wages. That's 12 months multiplied by that 12. All that full amount will have to be deposited. 12 times that will have deposited with the authority, with the tribunal, whatever it is, for them to deposit that in a bank account until the case is being determined, heard, and order passed on that. So that is the two things there. That is the salary, one is salary, second one is reinstatement order. Then every appeal under section 1 shall be supported by a certificate, issued by the president of the labor tribunal to the effect that the security as specified in subsection 1A has been duly furnished by the employer. That certificate must be carried on for any application to a higher authority, high court. The president of every tribunal, a labor tribunal, shall cause all monies furnished as security to be deposited in a bank account until that is being heard and determined that monies will be bearing interest on that money which is in the bank deposited in cash by the employer, the affected party. Then 3DDD, employer appeals to Court of Appeal for a writ against an award. You remember the word? Labor tribunals always give orders. The arbitrators give always awards. The industrial court always gives the award. These are the words. A tribunal, they pass orders. Then arbitrators pass awards. Industrial court pass awards. The commissioner has fair and amicable settlement. He can't pass orders. He can't pass awards. He will have to have only a fair and amicable settlement through conciliation. Through conciliation, he can have only fair and amicable settlement. But here under the Termination Act, he can pass orders. That's a special piece of legislation. If not, it will be always conciliation and try to bring about a mutual agreement by parties. That is the main idea of the commission, but not on statutory claims. Remember, statutory claims, no. You can't come to any agreement on statutory. EPF, then salary, then overtime, annual holidays, public holidays. Those are what is laid down in the law. That is laid down in the acts. Those are statutory claims. Those you can't compromise. Those, if the employers failed, it's nothing but the employer will have to redo that and repay that, or else it will be a judicial case filed in the court of magistrate court at the initial stage. Right. Then entertain such application and furnishing security. But the main idea of this amendment is security in cash for any appeal to a higher court or going up against that order. So Commissioner General, if the application directs payment of sum of money to the worker equal to such sum. The Commissioner of Labour shall deposit the sum maintained by the Commissioner. Commissioner can maintain a account approved by the bank and deposited this amount who the employer fail in that amount of money in cash has to be deposited. So it may be the tribunal, the commissioner, or whoever it is, the authority who is in authority when they pass any amount of money and that is not adhered by the employer, that money will have to be deposited. Then only they have the right to appeal against that. Every application shall be supported by a certificate issued by the Commissioner of Labour, that is security, that if it is coming down to the Commissioner of Labour authority, then it is the authority of the Commissioner of Labour to deposit that money and get that money and deposit it in his account. Then coming on to 33A, if the employer dissatisfied with an order of a magistrate on a written complaint made by the Commissioner General against such employer due to any failure to comply with such order of a tribunal, industrial court, arbitrator, initially the Commissioner of Labour will go to the magistrate for any violation or failure on the part of orders given by the tribunal, awards given by the arbitrator, awards given by the industrial court, made in favor of a workman, makes an application to invoke revision jurisdiction of High Court, shall at the time of such application furnish to magistrate court a security amount equal to such sum in cash, where the order of such application directs payment of such. Here again, it should be in cash deposited with the commissioner, and commissioner will deposit it. In the case of order, the registrar of magistrate court shall cause all security to be sent to the Commissioner of Labour to deposit. So if it is magistrate court, the registrar there will have to collect that and send it to the Commissioner of Labour to deposit in his account until it is heard, case is heard and decided and determined on the order. So that is what is intention of that particular amendment. Then every application shall be supported by a certificate. If you just remember that this particular amendment goes on with the supporting and furnishing of a certificate to deposit the money, that amount of money before going forward for any appeal. If you have that in mind, and you can go through this particularly in what sort of cases that they can go and where to deposit and all that. The commissioner shall refund, that's the point. Commissioner shall refund the sum furnished with the interest to the relevant party. It can be to the workman or to the employer back. According to the judgment given past, the commissioner will have refund that with the interest earned on that to the relevant party on the final order of the High Court or the Supreme Court or the Appeal Court, whatever it is, whoever it is, will have to be refunded to either to the employer or to the workman as it is, how it is being determined. Then Industrial Disputes Special Provisions Act number 19 of 22, an act to make special provisions to empower. Now the thing is this empowering the Labour Tribunal. The whole idea in this amendment is to empower the Labour Tribunal. Because at the moment, as you all know, Labour Tribunals, they cannot enforce their own order by themselves. It has to be passed on to the Labour Commissioner, and Labour Commissioner will file action in a court of law. The Labour Tribunal President's order is been carried out by prosecution done by the Commissioner of Labour. So the whole idea in this is to empower and give more authority to for the enforcement of the orders and other awards and all that through this amendment. Act 2 makes special provisions to empower the Labour Tribunal to hear, try, determine, and dispose of all enforcement proceedings and prosecution under the provisions of specified. Remember the word specified enactments, not all. Provisions of specified enactments. That's important why the legal draftment has put in there that there is a limitation. Specified enactments and for matters connected therewith incidental thereto. This act will come into operation on such day. Minister may, in consultation with the minister, assign the subject of justice appointed by order, published in the Gazette. Appointed by, so minister will have to publish in the Gazette. Then only this will come to have the power. Have the power to enforce. So the minister, in consultation with the justice minister, will have to come to an agreement and publish this in the government gazette. Then only that has the enforceable power. Labor tribunal, every labor tribunal, in addition to the powers, suits given by a law, exercise powers conferred on a magistrate for enforcement of any award by arbitrator, industrial court, or any order of a labor tribunal or decision of the commissioner to recover any payment upon a certificate issued by the commissioner or implementation of the provisions of the enactment specified in. So by this, the tribunal has power to exercise and to power conferred on the magistrate, conferred on the tribunal to file action in courts, magistrate court, to enforce the orders or awards given by the arbitrator, industrial court, on any order of a labor tribunal. And furthermore, a decision of the commissioner to recover any, if the commissioner has decided to recover any money, that also could be enforced through a certificate issued by the commissioner. You know, when you say certificate issued by the commissioner means that is non-summary trial. That means certificate issued by the commissioner in certain legislation, certain enactments. That means the certificate means there is no plaint and charge sheet file. No plaint and charge sheet file, only a certificate. There is no trial stage. There is no question of asking the correctness of the certificate, the how the calculation has been done, and all that is the magistrate court has no power on to, and it's a recovery court. It's ask the employer to show cause, and on finding that it's imposed by way of a fine, that amount of money. So that will, the certificate system on EPF and various other enactments are there, so that once the certificate is filed, it's non-summary. There is no trial, and the workers need not, they are not summoned to courts and put to the witness box, and no cross-examination, no presentation, leading evidence, nothing of that sort, you see. So that is what is meant. You should keep that in mind, that once a certificate issued by the commissioner, that limits all that, and that's a recovery court. Then jurisdiction of labor tribunal will be limited. Jurisdiction of a labor tribunal will be limited to a judicial division of a magistrate court as demarcated under the Judicature Act number 2 of 1978, where the labor tribunal is situated. So that's a limitation there. So the labor tribunal will file that action in the judicial division of the magistrate court. Jurisdiction of a labor tribunal referred to in column 1, down there you'll find schedule 2, shall be limited to the judicial division of the magistrate court in the entry in column 2 of the schedule. One moment, hold on. Then, sorry. For the avoidance of doubt, in some of the new legislation laws, I have found this particular section to avoid the doubt. So if there may be a doubt and not clear, difficulty in understanding the intention of the legislature. These are all passed at the legislature and framed by the legal draftman on the advice and instructions of the authority regarding this particular act. So to avoid of any doubt in the magistrate court, avoiding doubt, it says, magistrate court shall continue to exercise such other powers other than the powers under subsection 1. I dealt with the powers of the subsection 1, the earlier part, as specified enactments in any judicial division of a magistrate court, including judicial division of the specified. In other words, there are certain laws and enactments where must be carried out and be tried, and the judgments passed on those enactments through a magistrate court. Through a magistrate court. That is what is meant by some enactments, some laws can be dealt with under that previous section by empowering the labor tribunal presidents. You know, that is in short. That is one meant by that is that. Then President of Labor Tribunal, in column 1 of Schedule 2, you'll see down there, shall have the power to hear, try, determine, and dispose cases in a summary way to the enforcement of any award made by an arbitrator or industrial court, or any order made by the Labor Tribunal under the provisions of the Industrial Disputes Act, or any decision of the commissioner, or to recover any payment on certificate issued by the commissioner, implementation of any specified enactments. Registrar should be appointed. Now, under this, this appointment of a registrar was not there. Now, this has introduced the appointment of a registrar under this particular amendment should be appointed and a special staff to implement the functions under this subsection 1 and 2. For this, under this amendment, so they have to create a position for a registrar and a staff to carry out those functions. Then the evidence ordinance shall mutant this apply to and in relation to the procedure to hear, try, determine, and dispose of the suits or prosecutions before the labor tribunals. So, without disturbing the main enforcement or the idea, there can be changes without making an interest that evidence ordinance can be taken. Where normally evidence ordinance is outside the labor tribunal. They need not abide by the second one says, but the evidence ordinance shall not apply for the conduct of proceedings under the 31B of the industry. That is, before the labor tribunal, under the labor tribunal, the evidence ordinance does not apply. So every single fact should not be proved in accordance with the evidence ordinance, any proceedings before the labor tribunal. But in the previous proviso, it says in other cases, the evidence ordinance will apply. That is what it says. So there are 48 labor enactments listed there, whereby the magistrate court could be heard before the magistrate court, and the others to be heard by the labor tribunal. Then there are 37 labor tribunals there. I have not listed out the jurisdiction because it says a long list, you know. You will have to get that amended read and go through those judicial districts and relevant districts and find out, because the long list running into a few pages are there. Then we come to the next one, termination of employment of workmen special provisions amendment. As I told you, this was known as a draconian law, dangerous, because these are one-sided law, they said, you know, at the very beginning, one-sided law supporting the workmen only. That was the idea, but this was promulgated early in 1971. number 45 of 1971, due to various economic situations and curtailment of material, importation of material, and shortage of products and various things, and the employers were the tendency to reduce the number of employees. That's the idea behind, tendency was to cut down the labor force and restructuring because of loss of raw materials and difficulties and loss of income and various things. So during that time, the finance minister was Dr. N.M. Pereira, 71. So this was introduced not by the labor minister, by the finance minister at that time, Dr. N.M. Pereira. He brought in this piece of legislation, but enforced by the Commission of Labor because of the economic situation and the manufacturing situation at that time in 1971, where there was a curtailment of the industry. To avoid that, just to put people on the road, to prevent that only. So that's the idea. And that was, it was somewhere in June that was brought in, but retrospective effect. So that time it was argued, and a lot of arguments were there before the legal luminaries, saying that retrospective effect. This was brought in June, I remember, and brought in to be effective on the 1st of January. Backdated. So that time it was criticized that it is not done, it's not according to law, and retrospective effect is not bad in law. Bad in law, that was the term. Anyway, I just wanted to keep you informed that particular instance of that time. Then TEVA, I'll call it in shortened form, Termination of Employment of Workmen Act, amended in subsection 1 by the repeal of paragraph C and substitution. This one. To the termination of employment of any workman where such termination is effected upon the workman attaining the minimum retirement age of Workers Act 20. Now, this is a new piece of legislation. This minimum retirement age of Workers Act number 28 of 2021. This is a new piece of law legislation. Now that was affecting the conflicting with the Termination Act, to get that doubt away, so that any person who is coming under that minimum retirement age of Workers Act, you see, and any conflict, that minimum retirement act will be overpowering, and that termination cannot be enforced in that. Once you go through that, you will understand this, because of the minimum retirement age. Minimum retirement age is 52 years. As you go down, we'll see that 52 years. So anyone who is working and who has reached the age of 52 cannot be under this minimum retirement age Workers Act. They cannot be retired. They can't be asked to leave under certain conditions, under certain terms. That will be. So this is conflicting with the Termination Act. If they retire, if they terminate, so to avoid that, they say that minimum retirement age workers, if it is applicable, that will supersede that piece of legislation rather than the Termination Act. Just because to understand fully, I'm just giving you just parameters and a sketch of this, is so that you will have to go through and understand properly, or because these are to be enlarged, and to elaborate on this, there should be another lecture lecture series to explain what is really should be understandable and what is really expected out of this. Because there is time frame that I'm just enlightening, just giving you a broad picture so that you all can exercise, you all can study on this and broaden your broaden your education through going through this in fully by going through this particular amendment. Now you know the amendments. So you will have to get through the original act, original law, and put these amendments together and find out where and how it is practicable and what is meant by this amendment. I'm just telling you, because these things to be explained, that will take a long time. Right. Then this act may be, again, the Termination Act, that's in 23 of 22. 23 of 22. Remember these amendment dates, and remember when you quote any amendment, the year and the number is very important. Just if you say 22, there are so many amendments in 22. So, and 21. So 23 of 22. You have to go through that, and section 2 of the termination of employment of workmen special hereinafter referred to as principal enactments hereby amended as follows. Are you all with me? Can you hear me?
Yes,
Hello?
sir.
Right.
Yes, sir. We are with you.
Thank you. Thank you. I just, because some technical errors can happen, and sometimes I'm relating, I'm going through the lecture and you all may not follow it up. Anyway, by the insertion of immediately after section 3 thereof, that is section 3 of the termination, where an employee is convicted of an offense under subsection 3, such employee shall be liable if he continuously fail to comply with the decision made by the Commissioner General under subsection 2 to pay the workman in addition to any fine imposed under section 3, an additional fine of 500 rupees for each day on which the non-compliance is continued after the conviction. So if it is convicted, means he's found guilty. After that, if they delay in paying that, for every day the delayed, additional fine of 500 rupees will be imposed and will be in addition to that to the worker. Remember that. Where an employer fails, these are very hard rules and regulations, punishment is very hard. And so where any employer fails to pay any sum payable to a workman under paragraph C of subsection 2, such amount may be recovered by an order of a magistrate court by which the employer was convicted, and if it were a fine imposed on him by that court, an amount recovered shall be paid. So when you say fine, that's a punishment. Whenever you when you see the word recovered by way of a fine, means you are punished. It's a sentence. It's a sentence. If you use any act, if you use the word fine, and that you are found guilty and you are punished. A recovery is a different thing. You understand? Then section 8 of the Principal Act, hereby amended in paragraph 8 of subsection 1 thereof by substitution for the words fine of 50 rupees. Earlier it was 50 rupees fine. Now it has been increased to 500 rupees. That is for the delay, for the delay, not the punishment for the offense. This for the delay. The small punishments of 50 rupees going up to 500, these are, remember, these are not the main fine for the offense. These are for the delays after conviction, the delay in that, for that period. The following new section are hereby amended, inserted immediately after section 10 of the principal enactment, and shall have effect as section 10A and 10B of that enactment. 10A, where an employee is dissatisfied. Remember the word dissatisfied. Employee dissatisfied. He's not willing to carry out. He doesn't agree. He doesn't agree. He doesn't follow that. He doesn't want to follow that. Dissatisfied with an order of a magistrate court, such employee may make an application, revision application. You call that revisionary application by a written petition against the order to the High Court, Provincial High Court, established under Article 154P of the Constitution, to the province within which such magistrate court is situated. So they can apply to the Provincial High Court, and if they are dissatisfied, for a revisionary application to revise what is laid down, what is given by the Commissioner. They want to change that, alter that, or revoke that. Okay? Then every employer who makes an application under subsection 1 shall furnish to the magistrate court a security. See, again a security in cash. Now, this tied down. Now, these things were not there earlier. They can just appeal and that worker will have to be just idling for years and years without anything. Without any consolation, he will have to, and the department will go on fighting the case in the prosecution and going to courts and coming back. But here, the employee is bound to pay the cash amount and deposit that if he is going to. So it's not easy. Not easy. He will have to deposit that. Then only he can go up. That is, he tied down to that. Remember that. Without which is the subject of such application, direct the payment of sum of money to the workman, an amount. That is, if only the salary point is there, that amount of money will have to be deposited. Deposit, no reinstatement. Without reinstatement, only if it is a salary, that amount of money will have to be deposited. And the certificate must be issued that to the magistrate court that it has been secured and deposited. Then only he can go up in his appeal or revisionary application. So, because through my experience, the employers will be appealing, going up to the Supreme Court. The worker won't get anything until that is heard. That it will take 3-4 years and heard, and final judgment will be passed on favor of the employer or in favor of the worker. Whatever it is, the worker will not be benefited, and the department will also be going through in the high courts of appeal and Supreme Court, of course, with the assistance of the State Council, with the Attorney General Department, and going on for cases. So under this amendments, what is, we will keep in mind that the employer cannot just easily get away. He will have to deposit that amount of money, then only is allowed to go up. There is a certain restriction on that restriction for him just to, as a film, for flimsy things, they can't appeal and go up, justifying the employee or the workman during that period of time. Then every application made under subsection 1 shall be supported by a certificate under the registrar of the relevant magistrate court to the effect that in this case, registrar, that's in the magistrate court, of course, registrar will have to certify and specify the subsection has been duly furnished. He will have to issue that certificate. And the registrar of magistrate court shall cause all such sum of money furnished as security under subsection 2 to be sent to the Commissioner General, deposit in, because this has initiated to the Commissioner General, no? So finally the payment back to the employer or to the workman will be through the Commissioner of Labour. So that is why it is being sent back by the registrar to the commissioner for him to retain that money in a bank account, and finally with the interest and all that will be repaid back to the employer or to the worker according to the judgment passed on that case. That is the idea behind. So where an employee is dissatisfied with an order made by the Commissioner General under 6 or 6A, the 6 or 6 is closure. 6 or 6 is closure of an establishment, closure of a company. Now, Termination Act, they can go. They can go before the Commissioner of Labour if it is closed. If they can't go, and Commissioner cannot hold on and say, no, you can't close that. You have to employ the workers and keep them going. No, Commissioner has no power to give that order. So in that 6 and 6A, Commissioner will have to allow him to terminate the service of the workers. That is 6 and 6A under the Termination Act. Employer may make an application to the Court of Appeal against such order for the issue of an order in the nature of a writ. Now, in 6 and 6A means, in other words, closure. Now, if it is closure, it will end up in the formula, in the compensation formula published by the Commissioner of Labour with the approval of the Minister of Labour. So in other words, remember this closure, termination 6 and 6A. That is how it applies. Every employer who makes an application under subsection 1 for the issue of an order in the nature of writ shall furnish to the Court of Appeal security in cash where the order which is the subject of such application directs. Both the payment of sum of money and compensation and the reinstatement. Now see, 3 things. payment of sum of money, that is the salary or whatever it is, earned wages. Then coming on to the compensation, formula compensation amount, and the reinstatement of an amount of money as salary, wages, which is to be calculated from the date of such order to the date on which such workman shall be reinstated. Up to that reinstatement date that whole that back wages will have to be calculated. Remember that. And an amount of 12 times the monthly salary, 12 times the monthly salary, that is for reinstatement. Wages, on top of that, wages that will have to be deposited there. Only the payment of sum of money to the workman as compensation of an amount equal. If it is only the compensation, that amount of money will have to be deposited with the authority and that will be paid back. Then every application for the issue of an order in the nature of writ made under subsection 1 shall be supported by a certificate under the hand of the Commissioner General to the effect that the security, again the security of money will have to be furnished. Commissioner General shall cause such deposit of money with the interest and paid back to the applicable party. Then the Commissioner General shall refund the sum furnished under this to the after the final determination of the application of the Court of Appeal, Supreme Court, to the relevant party. Section 14 of the principal enactment is hereby amended by substitution for the words fine not exceeding 1,000 rupees, the fine not 20,000 rupees. Here it had been only with 1,000 rupees and it has been increased to 20,000 rupees by this amendment. See how these amendments have gone through. Then Termination Act formula is there. I have these from 21, because earlier one of 2005. Before that also there was one. And this latest is 20 Gazette notification, and February, it was gazetted 25th of February 2021 formula, and dated 19/2/21. This is the formula, 1 year to 5 years, the service period. Then the monthly salary paid to the as compensation for each year. For each year, 2.5, and the maximum compensation 12.5 months salary. So second lap is 16 to 14. That period of time. Then it has gone down to 2 months salary. Then 30 months, 0.5 months. 15 to 19, 1 to 1.5, and 38 months salary. Then 20 years to 24 years, within that period, it's 1 month salary going up to 43 months salary. 25 to 35, it's going up to 0.5 salary, half the salary, going up to 48 months as compensation according to the formula. Then on termination of worker who has less than 4 years service, office service. Now, termination of worker who has less than 4 years left office. Now only he can go less than 4 years to go up to the retirement age. Then paid either the aggregate salary for the denied period. For that period, the total of the salary that is denied, not paid, either that aggregate salary, that is addition, the total of that salary of the denied service, means that he cannot serve during that period, according to the or compensation according to the formula, whichever is less, whichever is less, if the period of denied service is. Then if it is only 4 years denied, either the 4-year salary together or the compensation amount according to the formula, then whatever is the lesser amount is the entitlement under the law. Then service period more than 4 years, compensation shall be according to the formula. If the denied period is more than 4 years, the compensation shall be according to the formula. Then no amount in the maximum, it was 1.2. Now this is 2.5, 25 lakhs, no amount of excess, 2.5 million shall be paid as that is the highest. However much the salary anybody draws, maybe a very big salary, but the compensation has been limited up to 2.5 million as the compensation according to the formula. 25 lakhs. Salary means, so now they have explained what the salary means. Salary means basic salary plus cost of living. If they are paying the cost of living, that amount. Cost of living or any other similar allowance. Why? Because don't be misguided with this word. Any other similar allowance means, you know, allowances for attendance or production or presentation or whatever it is. No, those are not counted. It should go with the living word. With the word cost of living or any other similar allowance means it should go as a living allowance. This is there with the EPF Act also. So the people say attendance bonus, production bonus, traveling allowance, fuel allowance. They call, but those are not counted as allowances for that matter. It should be only cost of living, and any other similar allowance means similar to cost of living. Living word is there. Remember that. Year means completed period of 12 months in relation to the first year. So in relation to the first year, it's 12 months in relation to the employment, and includes 180 days of service. Now, in these 180 days of service, you go through that carefully. They say holidays, annual holidays, approved leave, appointed, all that is counted within that period. If he has 180 days put in, he is covered for that. Sorry. Then Maternity Benefits Amendment Act. Now we are finished with the termination. Now we are coming on to the Maternity Benefits Amendment Act, number 15 of 2018. Now, in that piece of legislation, it's incorporated that piece of amendment to the Shop and Office Employees Amendment Act number 14 of 2000. This going together. Now, these are two different enactments. Maternity Benefits Ordinance. When you say the original one is Maternity Benefits Ordinance. When you say ordinance, that means before the independence, before 1948, those are ordinances. Ajna Panat. After the parliamentary system came, those are acts of parliament. Now, the original act is Maternity Benefits Ordinance. Now, this 2018, no, that is why it says Maternity Benefits Amendment Act number 15 of 2000. In that itself, it's incorporated the Shop and Office Employees Act number 14 of 2018 to deal only with the maternity part. Only with the maternity part, not disturbing working hours, annual holidays, public holidays, remuneration, not dealing with any other things. Only this amendment 14 of 2018 Shop and Office deal with the female employee giving birth to a child, delivery. That deals this particular section. 18H deals with that. And it says nursing, because nursing a child, this was not there. Remember, under the Shop and Office Employees Act, nursing a child and giving intervals to go and feed the child, milk feed the child, that was not there, Shop and Office earlier. Now that has been given, that nursing a child under 1 year. Remember, these are things that you must be keeping in mind. Under 1 year. So, nursing a child under 1 year be allowed in a 9-hour work period. If the work period is lesser than that, this will not apply as it is. So, in a 9-hour period of employment. 9-hour period of employment, 2 nursing intervals. This was not there earlier. 2 nursing intervals. If crèche means 2. Lama daraka garyak. Lamai balagan stanayak. Lamai rekabalagan. This was, crèche, this is very old in the history where in the plantation sector in very old days, I was serving in the upcountry in the year 1966 period. I was serving in the upcountry Hatton, Nuwara. That period, crèche means the pluckers, tea pluckers can keep their children in that small building, small place where to keep the children, and an old woman, disabled or deformed or difficult, who has undergone something, not physically disability, that woman is paid a child rate and asked to look after the children when the mothers are plucking in the tea estates. So that place is known as crèche. So they come and feed the child. The mothers of the children will come to the crèche and feed the child and go back again to the field for plucking. That is, if you just keep that mind, provided in not less than 30 minutes. So in this case also, if there is a place to look after the children in that workplace, so not 1 hour, 30 minutes given for interval to come and feed the child if the child is under 1 year, old. And if no crèche, there is no crèche, then not less than 1 hour. Then if there is no crèche, then that means 1 hour is given, either the woman to go home and feed the child or whatever it is. A 1 hour interval is given in addition to normal other intervals to go and feed the child of under 1 year. In addition to any interval provided for meals or rest, that's 1 year, one hour is given for that, no? So apart from that, in that case, 3 hours altogether. 1 hour for interval or meals, 1 hour, and 1 hour for feeding the child. In other words, 3 hour period, they can, during that period, can make use of to feed the child. For purposes of employment, in this time is taken and regarded as having worked. So that period is taken as having worked for all the intents and purposes. Then the period entitled for payment of maternity benefits. Now we are coming to the real maternity benefits or Amendment Act, this part. You see, as I told, the Shop and Office Act defines the confinement period and the maternity benefits by the number of days. 14 days prior to the confinement and 70 days after the confinement. In this one, still it goes as the Maternity Amendment Act, it goes as weeks, It goes as weeks. Still it goes as 2 weeks. That is 2 weeks up to and including the day of confinement. That is for the confinement. 2 weeks prior to that, the woman worker can be on leave and up to the confinement date. And 10 weeks after the confinement, that's maternity. There you have 14 days and 7 days. Here it's 2 weeks prior and 10 weeks after the confinement result, but that is a live child. Child is live. This one of 2 weeks prior and 2 weeks prior. 1 moment. 2 weeks prior and 10 weeks after. 10 weeks after. So, but if it is not a live child, 6 weeks, that is 2 weeks up to and including the day of confinement. 2 weeks up to and including the day of confinement, and 4 weeks following the day of it does not result, that's a live, not a live child, maybe a dead child, dead child, stillbirth, you call it stillbirth. And they specify the what is meant by the stillbirth or the dead child. They specify in the act, how it is being defined. And if it is not the live child, only 6 weeks prior and 6 weeks, that is 2 weeks prior and 4 weeks after. That's in 42 days in actual form. If a woman worker has worked on any number of days during the 2 weeks and shall be paid maternity benefits for such number of days after. That means before reaching the 14th day, if they deliver the child, that balance amount of days or weeks that they could not utilize could be taken after the 10 weeks period. They can add up to that and make use of that period accordingly. That is what is meant by that. Then pay such women maternity benefits at the prescribed rate for 2 weeks preceding confinement and 10 weeks following confinement for the issue of a live child. That there is a word prescribed rate. You must remember, if there is no actual salary paid, the fixed salary, then you have to go to the regulations. There are the regulations are there and prescribed rates are there in the regulations. So you have to abide by the prescribed rates according to the regulations. If not, there may be the wages board rate or contract rate or whatever it is. Then 2 weeks for 2 weeks preceding confinement, 4 weeks after confinement, not in the issue of a live child. If worked in any number of days, that is again that can be counted after the confinement period is over. Payment of maternity shall be in addition. Now this was not there earlier. This was not there earlier under the maternity benefits ordinance. That if any holidays are there, any poor days are there, and public holidays are there, all that is counted within that maternity leave. Within that maternity leave, any leave or facility or holidays or public or what, there will be no additional days added to that. But under this amendment, these are added together. This facility was there for the shop and office employees early. That's what I was telling you. For shop and office, that 84 days, out of the 84 days, there are poor days and public holidays and various other days holidays. That was added, and they went up to about 100 days, no more than 100 days, because those are added. Now, in this, for the other workers in the factories and plantation and all other workers who are not covered under shop and office did not enjoy that facility. But under this amendment, they enjoy this facility, and holidays and other things are added on to that 10 weeks period, added again. The new section means cannot get the maternity benefits from two employers, only for that confinement, only from that employer only the worker can get the maternity leave. You call this maternity leave, huh? Maternity leave. So there is a problem with that word. Now, under the shop and office, they speak of remuneration. Therefore, the remuneration that has to go in for the EPF, ETF. But when you say leave, there's an argument on that. When you say leave, that means you are not earning that. It's a benefit. Maternity benefits on it. The word is benefit, no. It doesn't say anywhere remuneration. It's a maternity leave, maternity benefit. So there's an argument on that and say that this is not an earned leave. Therefore, you are not supposed to pay for the EPF like that. But then generally all employers pay. Through my experience, I know all employers pay the maternity leave period amount also for EPF and ETF. Just remember that there's a argument on that. Shop and office says remuneration. That means earned word is there, padiya. That means they should go for EPF. This one, it says benefit all the way. Benefit. So when you say benefit, that means it's not earned. The EPF always say earned salary. EPF doesn't say salary. Remember, it says the earned wages. It should be earned. Earned means by working. So during this period, the worker doesn't work. So that means the argument says that this is only a benefit and not covered for EPF. I mean, that was just keep that in mind as a argument that is going on. See, so then coming on to a new section, within 1 week of confinement, give notice. Now, under this particular, now this is not there in the Shabanavich. Within 1 week of confinement, give notice to the employer the date confined to ascertain the number of days she will be permitted to absent herself and whether the confinement resulted. So within 1 week, at least the husband will have to go and inform the employer that the delivery was on this date and the child is live child or dead child, stillbirth or whatever it is, will have to be notified to the employer so that he will decide on the number of days to be given as leave and starting from which date. The receipt of notice permit woman, after receiving the notice, the word notice, then woman is allowed to be out of employment during that period. Shop and office employees regulation for words. Now, for 14 years, I told you earlier it was 12 years, then it was risen up to 14 years as child. Now it has been again risen up to 16 years. So wherever you find the word in the Shop and Office Employees Act, 14 years has been now with this amendment gone up to 16 years. So 16 years and above are people who could be employed, and under 16 is a child and cannot be employed anywhere, and it's a criminal offense, as I told you, punishable with imprisonment. So then employment of women, coming on to employment of women, young persons, employment of women, young persons and children, Amendment Act number 2 of 21, male, that the amendment I am talking of is male young person, male young person. Remember all these words. Male.
Excuse
Hello.
me.
Yeah.
Hello.
Yes.
Disturb you for a while. Hello.
Yes.
Yeah, I want to know that is there any kind of category, any kind of jobs they have to assign under 16 years old employees?
16, above 16, you can, under 18 and above 16 is known as a young person.
Yeah.
They could be used, they could be employed under
Yeah.
certain restrictions.
Yeah.
Above 16, they can be employed, in short. But there are restrictions, number of hours, then the starting period for them to work, then finishing period not going up to 8 p.m. And like that, there are with certain restrictions. Over 16, they can be employed. No problem with that. No problem with that. Male young person. The word male young person who has attained the age of 16 years, but under the age of 18 years, is known as a male young person. Now, in this act, everywhere it has been saying that between 16 and 18 years a person. Now it has been amended to say male young person who above 16 years and under 18 years is known as a male young person. Use that word. That is used in this amendment, employment of women and young persons. In this act, amended act, the word is used as male young person, and the meaning is between 16 and 18. Then earlier, there was a clause to say that under 15, you know, under 15 in the plantation sector, the people, the women workers and the employees could be, if they are 15, they could be employed on the plantation. Under the plantation, they could be. Now that is amended and said they also must be above 16 years of age. They have just scrapped that 15 years now and instead put 16 years. So wherever you find in this act 15 years earlier will have to be now substituted by the word 16 years. In other words, 16 under 16 you cannot employ on any sort of plantation, industry, services, or whatever, domestic service. No, only should be above 16 years of service period. Then replaced child means under the age of 16 years. Employment of women means now in the night, you know, night. Remember, employment of women, here it's employment of women. At least 11 consecutive hours, including 10 p.m. and 5. That 10 o'clock in the night and before 5 a.m. in the morning, that should cover that period. And 11 consecutive hours. So it could be started from 6 o'clock in the evening and go on till 5 o'clock. 6 to 6 is 12 hours now. So if you employ from 6 o'clock then it's all right. And the night will start only at 10 o'clock and till 5 a.m. That 11, without a break, 11 consecutive hours will be known as the night work for a female worker. Then employment of persons under 18 years means at least 12 consecutive hours, which shall end not less than 6 a.m. Now, there is some particular things that you have to keep in mind. Under 18, above 16 also can be employed in the night, under 16, over 16 and 18 can be employed in the night also. But there are certain restrictions, and they should not later than 6, that before 6 a.m. that their work period must be over. If you go into the act in detail, you will understand what is really meant by this particular section and dealing with this that age limit. You have to go through that because there are so many things that is confusing and doubts are there. So you have to fully understand to get a good idea about this. Then this different section. If attain the age of 16 years. Now, anybody attaining the age of 16 years shall mean, remember, shall means master. May means you can know, you cannot know, you can think it over. It may be this way or that way. But when in any act, if you use the word shall means it's a must. Attain the age of 16 years shall include 7 consecutive hours. There, see, 7 consecutive hours falling between 10 p.m. and 6 a.m. Now, there are the time 7 consecutive hours between 10 a.m. 10 p.m. in night, not before that, between 10 p.m. and 6 a.m. And if they have attained 16 years and undergoing a vocational training, remember, I don't know what purpose it is even, but that is in that. For vocational training in the baking trade, only that particular trade, only in the baking trade, or any apprentices in that trade. That's a trade learners who are undergoing a training in the baking trade. 7 consecutive hours can be employed over 16 years of age as a vocational training. As a vocational training, you work during the night in that industry, prohibited for all workers. If it is prohibited for all workers, but still this vocational trainees can be employed over 16 years of age for 7 consecutive hours in the baking trade. The baking trade, falling between 9 p.m. and 4 a.m. That is the time, 9 p.m. and 4 a.m. That's the vocational training period. That is for baking trade, for manufacturing and for preparing this bread and other things, that's as a training. 9 p.m. and 4 a.m. instead of the period of at least 7 consecutive hours referred to above. Instead of that previous time, this is at 10 p.m. and 6 p.m. Now, apart from that, for this particular trainees, they say 9 p.m. and 4 a.m., 7 consecutive hours, they can be used on baking trade if the minister by order published in the Gazette. But that is also should be published by the minister in the Gazette. Here again, the young person means under the age of 18 for the words 14 years. Earlier, the act carried the word as 14. Now it is 18 years, substitute 16 years. Then we come on to the Wages Board's Ordinance. Wages Board's Ordinance. Now, these are very old piece of legislation, but now they call it Act because of the amendment. If not, the original one is Ordinance. 1941, but these 14 of 2019. Before this also there are about 6, 7. Remember, before these amendments, these only after 2010. Before 2010, I think there are 6 or 7 amendments to this Wages Board's Ordinance. In all others, it's like that. Before 2010, there were so many amendments. 6 amendments, 7 amendments dealing with various alterations and things in the Act. But this is after the 2010. 14 of 2019, section 4. So we have to go through section 4, replace. It was replaced by fine. Now fines have been increased. Just keep that in mind. This amendment goes on with the fines, increasing of fines. 5,000 not exceeding. So not below 5,000. Any offense under this, the magistrate will have to fine more than 5,000 rupees. I don't know whether that is whether that is for the in the present day, whether that's a suitable amount to be fined. I don't know. That's up to anyone to be debated on that. Anyway, not below 5,000 and not exceeding 10,000. Imprisonment of 1 year. Either way, by hard labor or simple labor. You see, then section 2A, some in arrears, some in arrears. If the sum is, there are some arrears not paid to the workers for a period not exceeding 24 months. That arrears run to about exceeding 24 months, a surcharge on that, 10%, a surcharge for each period of 12 months. So there is in addition to the normal salary, 10% will be added for the delay in the payment of that money. Then period to preserve records under the wages boards. You have, say, part 1 and part 2. Part 1 speaks of all trades. Part 1 speaks of all trades, different types of any person is coming under part 1. And wages record also a limited requirement is there for the wages period. But section 41 is in the part 2. That is under the wages boards. When the part 1 will not apply to wages boards. Part 2 will apply to wages boards. So section 41 falls on to the part 2. In that the wages period is there, mentioned there. Under section 41, period to preserve. It was in the part 1 and part 2 both. The records means the registers, salary wages, and all that was the employee will have to keep for the back wages only 4 years. Now that has been extended to 6 years. Up to 6 years, the employee will have to preserve these records for any inspection to be done by the Labor Department officials or whoever it is. So here the idea behind is that record keeping period 4 years has been extended to 6 years under section 44, that is under section 41, and the reference of the wages record. Here again, remember, up to now, section 41 speaks of a wages record as prescribed, but up to now it's not prescribed under regulations. So, I mean, no one can say that it is prescribed and this is type of a record that we are keeping as the wages record. But under the Shop and Office Employees Act, of course, there is the condition, that is a letter of appointment. Letter of appointment is there. And in that it specifies what are the things that the employer must maintain. We are in the section 41, they speak of under the wages boards, they speak of a record, but it is not prescribed that it should be in this form. It should be in the like form. It has not been prescribed by regulations. And fails to pay wages. Under section 21 only, under section 21 of the wages boards ordinance speaks of the minimum wages. Minimum wages specified by the wages boards are shown, or not shown actually, requirement says under section 21 that the wages must be paid according to the wages boards ordinance. So if you violate that, section 21, without paying the minimum wage, then there is a fine not less than 5,000, not exceeding 10,000, 1 year imprisonment. In addition, liable to fine not exceeding 500 for each day that after conviction, if the employee fails to pay the money for each day, there is a surcharge, and that will be paid by 500 rupees to the worker. That is meant by that. Then who fails to pay any worker any decision of wages board shall be guilty of an offense and liable to pay fine. Remember, fine 5,000, not exceeding 10,000. So if you remember that this amendment speaks of the enhancement of the fines, and the negligence on the part of the employer to immediately pay that. If not, there will be a added fine of 500 rupees for the delay after the conviction. Section 46 period of records again extended to 6 periods. Section 46 also speaks of the records. That is 4 years has been now extended to 6 years. Then the fine is 5,000. Then that is for the delay 500. That is what it says. And period extended to 6 years. That is what is meant by that. Now, this is a new section where, remember the important section, where outsourcing, give work to outsource. The main employer is giving to another party, to a subcontractor, to get that work done. But that is the part and parcel of the main business, main trade of the principal employer. But he is now giving it out for other reasons, giving it out to a third party, another contractor, subcontractor, remote employer. Principal employer will give that to a remote employer, subcontractor. So now that is restricted by 59A new section, limited. They speak of arrangement with any other person, that means a subcontractor, who employs workers on a regular basis. Now see, regular basis. That means not only 1 or 2 days and all that. That's a continuously, that fellow will be using these workers and getting the work done of the main business. Actually, the main business is for the principal employee to perform, but he is now giving out to a third party, and that contractor will be using the workers and getting. So that is restricted now, which is integral part of the main business. Now, such person employs workers on such contract of work. Arrangement shall be deemed to be about now the new word, disguised employment relationship. That is the word that I want to emphasize on. Remember, 59A speaks of outsourcing the main business to a subcontractor, and that is known as disguised employment relationship. That means the principal employer and these work and the type of employment, disguised employment relationship. If the commissioner is opinion, now this word opinion is a very dangerous word. He can form opinion, means that is what he has having is in mind. You see, commissioner is of opinion that it's a disguised employment relationship. He shall direct. Direct means direct. Whenever you find the word direct means it has a legal bearing. That means he is forcing. He's forcing down. Direct such employer to refrain from having. He said, don't do that. Refrain from having such work executed under such contract or arrangement. Employees now. Commissioner will have the power, and in his opinion, he may decide whether it is disguised employment relationship. If so, he will direct, means he will tell the employer that you have to refrain from doing this execution of this type of work. He can, and the person aggrieved. Now that the person will not agree with the commissioner's decision on that. Person aggrieved by the directive, by the force given by the employer, has the right to appeal to a special employment relations tribunal, not the labor tribunal, specially formed one to hear these cases. Special employment relations tribunal established under the Act. Within 30 days of the directive, when the directive is issued by the commissioner, within 30 days, the employer will have to, the aggrieved party will have to apply to the tribunal, this tribunal, special employment relations tribunal. Then the employment tribunal shall summon parties, call the parties to make a determination affirming or rejecting that, to give this okay or not, affirming or rejecting the directive issued by the commissioner. Directive issued by the commissioner, that will be decided by this employment relationship arrangement, by that special employment relation tribunal. Then after 59A, establish the special employment relation tribunal to determine appeal. So under 59A, they establish a special employment relation. I don't know whether it's functioning or not at the present day. Anyway, under the law, it is set in that way. So tribunal will consist of 3 members. Tribunal will consist of 3 members appointed by the minister. One whom shall be a retired judge of the Supreme Court. So the chairman will be a retired Supreme Court judge on that appeal board, Court of Appeal, who shall be the chairman of the tribunal. Member shall hold office for a period. The other 2 members will hold office for 3 years. And there shall be a secretary appointed to this tribunal. These are all spelled out in the Act. 59C, chairman of the tribunal shall inform the commissioner, and he will inform the parties of the decision. Decision will be published in the Gazette. Who fails to comply with the directive of the commissioner, now the commissioner has given the directive now, who fails to comply with the directive of the commissioner, violation of the decision of the tribunal, if you violate the decision of the tribunal, shall be guilty of an offense, and the commissioner will institute action in the magistrate court against that person. So file action, not a certificate, but plaint and charge sheet and tribal, and commissioner will file action in a court of law. That is what is meant by that. Then we can ignore this part. This part of the maternity benefits, we have dealt with that. Employees Provident Fund. Employees Provident Fund Amendment Act number 2 of 2012, Employees Provident Fund. When an employee becomes a member of the fund, that means the people who were having their private provident funds, approved provident funds, they have had approved provident funds. Those it's allowed. It's allowed under Section 27 of the Employees Provident Fund. Before this, Employees Provident Fund came in 1958 by Act number 15 of 1958. Before that, there were 96. At the moment, there are 96 or so private provident funds, but those are known as approved provident funds. But the Commissioner of Labour has the power to inspect them, go through them, and direct them. All that the Commission has power, and Commission has approved those private provident funds. But 1996, from 1st of February, these private provident funds were not allowed to have new private provident funds. From 1996 February, it was disallowed to have new provident funds created by companies or it is. But the existing ones is still allowed, and they function in that form. Now, when an employer becomes a member of the fund, when an employee becomes, fund means EPF, when an employee becomes a member of the fund, Commissioner General shall assign an identification number to such employee and employer. Now, out of these private provident funds, when they come on the EPF provident fund, then those are given new numbers. You see, assign identification numbers to the employee and to the employer to be coming under the fund means Employees Provident Fund. Any investment may invest monies of the fund to. Second one says may invest monies of the fund to purchase. Now, all these days that money, EPF Provident Fund monies, only 2% was allowed to use on any other assignment. But that was amended later on by the Parliament. And now in this one it says, may invest monies of the fund to purchase a land for a secretariat, construct and secretariat for the use of the fund. Now, that is how the new building of 36-story building in Narahempita, a new one, has been built under this amendment where they were allowed under this permitted to invest monies of the fund to purchase a land for a secretariat. Now we have a secretariat, 36-storied building in Narahempita, beside the old building, and that is coming under this particular, because of the particular amendment. Construct and such secretariat for the use of the fund. Then account for a period not exceeding 6 years prior to the date of. So once these, the interest period for the non-payment of period, the central bank will go back only for 6 years, not beyond that. Now, if there is the money to be accounted to individual accounts for the non-paid period, they will go back to earlier 6-year period only under this amendment, not beyond that. The member should have contributed. Then this one allows people to withdraw that 30%. 30% withdrawal came under this amendment. Now, to get that withdrawal of the 30%, that's not a loan. That's you are withdrawing your own money out of the fund. Now, for that matter, the worker should have contributed for 10 years, more than 10 or 10 years. Then should presently be employed. Now, if he's out of employment, he can't. See, he should be presently employed also, and has not less than 300,000 rupees in his individual account. More than 3 lakhs he should have. Then only he had access to go into withdraw 30% of his individual account money. Then for the purpose of housing, now that's allowed, not for everything. Now housing. Then medical treatment. One is housing, medical treatment may withdraw 30% of the balance in the account. Minister from time to time prescribe the maximum. Sometimes minister can increase this or whatever it is. He can, by regulation, allow this money to increase 30% or more, whatever it is. The member has to complete 10 years of service for a second. Now for the second withdrawal, again he has to complete for the second. Once he draws that first one, he'll complete the second year, 10-year period, he'll have to contribute. Then housing. For housing means construct a house, purchase a land to build a house, purchase of a house, redemption of the mortgage, if it is a mortgage, to repay that, a housing property, and settle outstanding balance of housing loan. If he has taken housing loan, to repay that, he can get this 30%. Medical treatment. For these are for medical treatment: heart surgery, bypass surgery, cancer, kidney, transplant, surgery, cesarean operation, and if it is hospitalization for more than 14 days, if he's hospital, he can withdraw that 30% to settle that bill. Then that is the APF member, the spouse, wife, or if wife is working, the husband, children are entitled to this medical treatment, to go under medical treatment at the rate of 1% to be increased to 2%. Now that means if there's a delay in the payment of the contribution, central bank, the non-submission of records, apart from non-payment of money to the central bank, the not submitting the proper records, returns, central bank, and it was for the delay 1% from the total amount at the surcharge for non-submission of records. Now that has been increased 2% of the total amount, not the surcharge. Surcharge will be for the amount will be 5%, 10% going up to 50%. This is non-production of records or returns to the central bank. Every employee having minimum. Now this is for electronic method. You have to, if he has more than 15 workers, furnish monthly return, such particulars to Commissioner General with copy to central bank from 1st of July 2012 by electronic means. Send that report to central bank with the commissioner, copy to commissioner. Section 37 on failure to find failure to do that, there's a fine of 2,500 fine will be, and 70 rupees for each day. The delay is for that. Then now the time is 9:30. I will just finish this, and we have to wind up because there are so many other slides to go in. Employees Provident Fund Amendment 23 of 21. 2021, employee, any particular time, and does not include a detached worker for a period of time specified, worker for a period of time specified in a social security. Now there are people, non-citizens, non-citizens of Sri Lanka coming in for social security agreement with the government of Sri Lanka. Now they are not, they are workers, but they need not contribute to EPF. That has been, there was argument on that. These repatriates, whether they should contribute to the provident fund or not. There was argument on that. Now, for special assignment, social security. This is social security, not any other job. Social security agreement applicable to such detached. The word is the detached. Now, disguised employment earlier. Now, this is detached worker. Now, covered employment, detached worker means international worker. He is not a citizen of Sri Lanka. He is coming to work on a social security agreement to perform that assignment or non-governmental assignment. On a temporary assignment, contributing to social security program in that country, exempted from paying contribution to EPF. Employer, international, they are known as international workers, who is a citizen of that country, not in Sri Lanka. Now, social security agreement means bilateral agreement. Sri Lanka is a party, exemptions to citizens of one country working in another country on temporary assignment. Not contributing to a social security in such other country. Now the time is 9:35. Just give me 2 minutes to contact the National Institute of Labour Studies about this matter. Hello, can you all hear me? Hello? Hello?
Yes, sir, can hear.
Now it's 9:35. I contacted the National Institute of Labour Studies because this Minimum Retirement Age of Workers Act, new act, that is going for a lot of slides are there to explain, go through that. Time factor is there. So the National Institute of Labour Studies instructs me to wind up now. And if we can arrange another program like this, we can go out, because there are now this is a minimum retirement age. Then this is going for a 1 minute. I will just show the other things also. These all slides going through that. Then see it has to be explained, all these things. Then coming on to the Factories Ordinance amendments. Then coming on to the Workmen's Compensation Act 10 of 22. That's also a little longer one. Then coming on to the National Minimum Wages of Workers Act. 3 of 2016, then coming on to the Budgetary Relief Allowance of Workers Act, number 4 of 2016. So there are 5 more like that, and that is ending with that. So that will take another 1 hour, so even more than 1 hour to finish that. So we will have to take up this on another time and finish with that. So I have to wind up now. If I can allow just 1 or 2 questions if you have to before winding up. Well, I have dealt, remember, you may not have grabbed everything because I have not gone into the explaining those particular sections and why those things have been amended like that and what does it mean and various things. If that is so, I could have taken only 1 or 2 amendments only. So I have just given a guideline, a reference guideline for you all to go up on that and go through that particular GED Act and Main Act and put these amendments together and see how and why and when and these amendments have come in and for what purpose when you compare with the main enactment, comparing with this amendment, you will understand that. So if you can get at the 2010 Labour Code of Sri Lanka. You can get that which was published by the Labour Ministry. If it is available, if you can go to the Labour library at the Labour Department, old building, the library. You can go through and see that. And when you have the main 2010 book with you, all the amendments are there. All what I have dealt with, all those amendments are there. I mean, the main acts are there with the amendments up to 2010. So when you compare with that, those particular acts with the main, with that book, you will understand how and when, why these amendments have come after 2010, up to 2023. Yes.
Thank you, sir. Thank you, our resource person.
Yes.
Former Commissioner of Labour, S.K. Ranaweera. Thank you, all of you.
Thank you.
Our next pre-webinar, next Sunday, resource person, Professor A. Sarvesaran. You can register from tomorrow.
Right. Right.
I will send the detail. Thank you very much.
Thank you. Thank you to all the participants who were with me right throughout. At the beginning, we had about 72. Anyway, I think I have tried my level best to do justice to the subject, but because of the time constraint and the practical difficulties in explaining each and every amendment in the real form. But if you want, you can ask the National Institute of Labour Studies to go in for further rectification and lecture method to go into and to get this done in a more fully completed manner. Thank you very much. Have a nice day. Good night to everybody.
Thank you, sir. Thank you for the valuable inputs. Thank you so much. Good night, sir.
Good night. Good night. Good night.
Good night.
Good night. Thank you.